Strout versus Central Maine Medical Center deals with the question of timing. Can you, in fact, have an offer of compromise or settlement when there is no pending legal action, when there's no lawsuit in play? And in Central Maine, in Strout versus Central Maine Medical, this was a case of a patient who came in, and a doctor diagnosed him as having inoperable cancer that had a survival rate of less than 1 year. Obviously, this would be quite traumatic news, and the trauma of the news isn't altered, at least immediately, by the fact that the doctor was wrong. In this case, the lab results came back, and the patient had a form of cancer that had a very good 5-year survival rate. And so the patient went from being told that he was going to die in a year to being told that he was quite likely going to live. And so he files a complaint, not a lawsuit, but a complaint with the medical center. And they write him a letter back saying that they've investigated this matter and the doctor should have waited for the lab results before telling him what he thought, but that the doctor, was a very compassionate doctor who, didn't mean any harm by this. And, it's kind of hard not to believe the doctor's story in this case. It would be, unless this were truly just a malicious person, why would you do this for some reason other than that you thought that was the best way to, why delay the agony of this if this is what you think it actually is. But it was also not consistent with the protocol for the hospital. So the question then is when the doctor and the hospital are then sued for the trauma that's inflicted by this incorrect statement, this incorrect information that the patient is given, can the letter that the Maine Medical Center wrote back to the patient, can that be admitted to show the fault of the doctor and therefore of the hospital? And the court says yes, it can. And there are two reasons. One deals with the rules of evidence and Rule 408. And Maine has a corollary 408, just like the federal rules of evidence, and they say the same thing. Under that rule, the court held that unless there's actually a legal dispute at issue, then the offer of settlement is not actually an offer of settlement at all. It's something else. It is an offer to pay something. It doesn't actually offer to resolve a legal issue. And remember, the goal of Rule 408 is so that we'll avoid litigation. Unless litigation is clearly on the horizon, the rule really isn't applicable. And then just because it's also in the case, and it helps to know that there's sometimes state statutes that will also govern the admissibility of evidence above and beyond the rules of evidence that all the states have. Maine had an apology statute, which says that if a doctor writes his patient and says, I'm very sorry this happened, I feel really bad, that those letters are inadmissible, much for the same reason that offers to pay medical bills are inadmissible. And in fact, the Maine Medical Center not only said, we're really sorry this happened, we're gonna write off your bill. So that statement was not only, it had some teeth to it. Not only did it say, we're really sorry, he shouldn't have done this, but it's offering to give them money. It just wasn't in exchange for a lawsuit that was clearly on the horizon or had been filed, certainly. The Maine apology statute does not allow in any statement just because it says, we're really sorry this happened, I feel really bad. It does allow in, however, an admission of fault. The statute very clearly says that admissions of fault are still admissible in the lawsuit. So this letter from the Maine Medical Center says he didn't follow protocol, he shouldn't have done it this way, but he did it with goodwill. And like I say, it's kind of hard to doubt that's wrong, and certainly that would be consideration in whatever damages were awarded to the patient. But the key here is that there has to be litigation, or it has to be on the horizon. There has to be an issue, a dispute that we are offering to settle. It can't just be a gift of money as compensation, as a gesture of goodwill. There has to be some trade-off between dismissing the litigation or implicit dismissal of the litigation um, in exchange for whatever is being offered. So again, worth noting that courts don't like rules that exclude testimony that's actually relevant and helpful. This letter is actually quite helpful for us resolving whether the doctor made a mistake and thereby causing emotional trauma to the patient, whether or not the doctor acted in good faith or out of goodwill. What he did was in violation of the hospital's procedure, and what he did inflicted some emotional trauma on this patient. That's relevant for us deciding whether the doctor did wrong or not. The fact that the hospital said he did wrong. So the courts don't like excluding relevant, helpful information. And here again, unless it fits exactly within the parameters of the reason for the rule, that we want to discourage, we don't want to discourage settlement offers. This was not a settlement offer because there was nothing to settle, because there was no lawsuit.